Hello, friends. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IS Law Firm. In this video, I want to talk to you about a hot topic, which is evidence for asylum case. What type of evidence you should use, what kind of evidence you can use, how to obtain evidence, whether one type of evidence is better than other. So evidence, well, first, evidence, what it means for your asylum case. It means supporting documentation. So evidence / supporting documentation for asylum application, whether it's an immigration court or whether it's affirmatively. We'll name this video as such. So what type of evidence exists? There are certain types of evidence. The first and most important type of evidence is your testimony. It is what you will tell and what you will write to the asylum office or to the immigration court. That's the most important evidence. It doesn't matter how many documents you submit. I mean, it all matters, but it doesn't matter if you don't provide sufficient detailed testimony of your own. It will not matter how many documents you submit, how many medical records, police reports, or anything you submit. So your testimony is very important. And your testimony begins from the time you prepare and file your asylum application. So we do hear quite often that somebody tells us, oh, we filed our asylum application quickly to get the clock running. And immediately the red flag is raised. Did you prepare your declaration thoroughly? Did you prepare a statement that you filed in support of your asylum application? So it is extremely important to start your case, preparing your case very thoroughly, to prepare your detailed statement as soon as you begin your asylum application process. Do not file a random statement. Do not file unfinished application for asylum without providing detailed declaration. Your work permit can wait a little bit, but your application has to be detailed with a detailed testimony of your own, which is going to be in writing at the time of filing, and then you will testify in person in immigration court or in asylum office at the time of your interview. You must be very detailed and consistent, okay? I keep repeating this because that's extremely important. Anything you write at the beginning of your application, anything you write, provide in your asylum application or in your statement sticks with your case. And it becomes really hard to change or supplement this, especially if those events that you're trying to supplement have already taken place before you wrote this statement, this declaration in support. Then, down the road, changing it, the question comes up that why didn't you indicate it in the first time? Now, then you can explain that I filed to get my work permit, or I didn't think about it, or I forgot about it. But then you're putting yourself in defensive. You're defending yourself against the question. And just being in defensive already damages your asylum case. It makes it weaker, no matter, albeit a little bit weaker or too weak, doesn't matter. So it damages your case as soon as you put yourself in defensive in responding to a question which starts with how come or why. So to avoid this, make sure you prepare a thorough declaration in support of your asylum application. That's the first type of evidence. That's the most important evidence. That's the most important supporting documentation and evidence for your case is your testimony. Now, let's move on to the next type of evidence. Obviously, we have direct evidence. Direct evidence could be such as photographs, videos, medical records, meaning the hospital wrote in your declaration. Let's say in your case, you have that you've been, subject to some kind of physical harm and you were admitted to hospital and treated, and the doctor or nurse or whoever wrote a record of your injury. That's direct evidence. Although in civil courts it may be considered hearsay, but in the criminal it's not. It's basically direct evidence of the medical facility or medical provider stating that this person came to our facility with a broken nose, that, and your story tells the asylum office or immigration court that, you had someone punch you because of your political opinion or ethnicity or whatever that might be. So photographs are important direct evidence. if you had injuries and you took photograph of yourself, or somebody took a photograph of you being injured. So it's very important. It's very helpful direct evidence. There cannot be anything better than showing that, you're saying that you've been severely beaten up during a protest or whatever happened to you, and you have photographs showing you injuries. Now, it's kind of semi-direct. What it means is that, it shows that you were injured, but it doesn't mean that you were injured because of the attack that you're claiming which was done by the police officers at the protest. But it still helps. It's basically corroborating evidence. So it's direct evidence of your injuries, but it's not direct evidence of why you sustained those injuries. But it still helps. It supports your case, your story. So videos of you, for example, you're claiming that you've been at a protest, which eventually was, dispersed brutally by the police and something, and you have a video recording of that protest, maybe from the news reports or so on, of the same protest, and you have a combination of that with a photograph of you holding a slogan. For example, I'm just giving you examples of this. It doesn't have to be necessarily related to political opinion or protest. It could be anything else. So you have some kind of video recording. We had a client recently who had security cameras in his house, and he had a video and photo evidence of SWAT team jumping over the fence in Russia, trying to arrest him and accuse him of bogus charges and so on, basically attacking him. So he had a CCTV security camera footages of that. So that was extremely helpful. What he also had is, while he was in the United States, the Russian Spetsnaz came to his house looking for him, and he wasn't there. So he had a video footage of Spetsnaz actually in front of his house by his gates, knocking the door, then talking to the neighbor, asking where his whereabouts. So that was extremely important. Now, if you don't have it, don't be alarmed. If you don't have photographs and videos, again, don't be alarmed. It's not required, but the more evidence you have, the better it is. If you don't have a medical record of the injury that you suffered or photographs of it, don't be alarmed. So the rule is you have to make every possible effort to get the best evidence for your case, every type of evidence that could have been obtained. Now, what if you cannot get that evidence? You have to demonstrate that you made all the efforts, you made the attempts to get that evidence in support. And in some cases, the evidence of you attempting to get evidence is maybe even more helpful than the evidence that you could have obtained itself. And here's why. For example, medical records. We're still talking about direct evidence. So sometimes I see a case, from one of the third world countries, and they provide medical records of every single simple injury that they had. That triggers suspicion because if you were slapped in the face, you wouldn't go to a medical provider to get a treatment. Now, even if it's a slight injury such as bleeding nose or anything, unless you have something serious, you wouldn't go to a medical provider, get a medical attention. So, if you suspect all these steps, sometimes I have a case, somebody was in 3 different protests, they've been attacked, harmed, and each time they went to doctor, got the medical record, they got police records saying that they've been detained and charged with hooliganism or participating in protests. Each time they got a perfect set of all the records and all of this evidence. That raises red flags. The immigration authorities here are not idiots. They know that in many of the countries, especially we work with a lot of Eastern Europeans, with Soviet countries. In those countries, you can pay money and get any kind of evidence you want. So that raises usually, any kind of evidence, what I mean is by like police report or medical record. In those countries, it's not a secret. Everybody knows this. You can go in many of the post-Soviet countries and pay a medical provider, and they'll write a report, put there anything you want. Unfortunately, that's the reality. And sometimes people with actual true reports, with actual valid medical records, suffer because of this reality, that people know that here in the United States, the immigration authorities, they know that you can get those records by paying. Sometimes I see clients bring in a photograph of police officer handcuffing them and arresting them. It's like perfectly staged photograph, and that raises a red flag, and I have to grill my client and tell them, hey, you sure this is not a staged photograph? I mean, they swear up and down, and unless I have, other than just my gut feeling, reason to believe that this is a fake photograph or somebody staged, maybe a relative police officer, then I cannot tell the client, no, I'm not going to use it. I tell them that, look, the same gut feeling that I had, and I asked you all these questions about it, the officer in the immigration office or in the immigration court, the judge may also have the same gut feeling. So maybe we shouldn't even use this photograph, although you're telling me that this is a real photograph. Your wife took this photo while you were being arrested, detained. So then I have to leave it to the client to decide. But the important take from all this is that, you don't want to make your evidence look like staged or forged or bought documents and evidence for your case. And if the third person, if your attorney or somebody who's looking at your case has that gut feeling or suspicion, then you should seriously consider maybe not even using that evidence, or providing more information about that. So for example, if you have a photograph, then you don't just want to provide that photograph of the police officer, holding a baton over your head. You also want to provide the background, who took this photograph and how you obtained it, who gave it to you, how this person, was it a journalist who was at the same time, filming the events transpiring at this protest. You want to provide a background information affirmatively, so you don't put yourself in defensive where they're asking you, how come, how are you, or whoever was taking this photograph, how come they were able to do it so peacefully and nicely while this officer was beating you up, again, as an example. So sometimes what we do is, we have a client who comes and says, I got tortured and I had to go to a medical facility, get treatment. Do you have a medical record? No, I don't, because I wasn't able to get it. I fled. The hospital wouldn't give it to me. So we tell them, okay, here's what we can do. We can find a lawyer or some kind of agency or company in your home country who can go to that facility and make an attempt, try to get a record. You're saying that you were arrested by the police, but the police, wouldn't make records of this arrest or detention because they wouldn't, usually make records of illegal actions where they unlawfully detain, protesters, take them to the outskirts of the city and drop them off there without any charges. Obviously, the police is not going to make that record of these actions, but it's not so obvious. Now, I say obviously because I know how it takes place in those countries where this takes place, but in the United States, the judge, the officer don't assume that they know what's going on and how it works. So, then what we tell them is, let's get them to try to get those records. And if they cannot, at least they can provide us a sworn statement or affidavit confirming that they tried to get those records and that they didn't. And if it's, for example, an attorney in that country, then that lawyer can also write an explanation that, we made an attempt, we sent this request to the police department asking to confirm that this individual was detained without charges. They refused, they said, no, we don't have any records. And then this attorney would write that, this is a common practice, that the police is not going to keep records of these unlawful actions by the police officers. They don't do that. And, or the medical provider or whoever, the clinic you went to, is not going to provide the records. We made the request, they're not providing. And here's why: because the medical facility knows that all of these individuals who came on that day for treatment were, abused in the hands of the police. And this is a government medical facility. Maybe they're not. Videos, photographs, or any kind of evidence is very important. You want to document that you have made those attempts. That's extremely important. And so it's sometimes much better than direct evidence. Then we have indirect evidence. It's more remote evidence. So it's not something that directly confirms what you're saying in your story, but it supports, it corroborates with your story. I'll give you an example. And I always give this an example because that was many years ago when I started my practice. I've been practicing for more than 16 years now, handling asylum cases. But when I started my practice, I had a case about an individual whose part of the claim, as part of the persecution that he claimed he suffered, was that his car was seized. His vehicle was captured and seized by these individuals who were working for the government. That just made him basically transfer the title, and they took it as a trophy as they were trying to punish him for his, I think it was ethnic origin and so on. So and that's a common practice in some of the countries. So we use the evidence that this takes place, but there was no evidence that there was no record of this car being transferred, the ownership, or the car being seized. All we were able to find upon making a request from his home country is a registration of that vehicle. Now, the registration of that vehicle showed that he had this car at one point, that he owned this vehicle, but it doesn't show that he lost it to these individuals because they seized it from him. But no matter what, he got asylum approved by the asylum office because that evidence supported his story. It supported that he did really own this certain type of brand of vehicle that he previously claimed by filing his asylum application and detailed declaration. And again, going back to how detailed your declaration has to be, it's extremely important. He had a detailed declaration with the evidence, explaining that what type of car he had, details as to what happened to him, what type of car he had, and so on. And then down the road, I think back then the asylum cases were much faster. I think several months later, he was able to get that registration document, which was consistent with what he wrote in his declaration, and that helped a lot. And that helped a lot to show that he was truthful about this. So again, indirect evidence is used a lot. I'll give you another example of indirect evidence. We had a client who was claiming that she was attacked on the way home from a delivery of some prescription of some medicine to she was working as an expediter, selling in the sales of some kind of medical equipment or some medical medicine to local pharmacies. And she was from Iran. And part of her claim was on the way home from one of the deliveries, she was targeted and attacked by a motorcycle. They came and attacked her, and they beat her up. The question was, was she walking to these places, or was she delivering by car? Because it's hard to imagine somebody working as in the sales of medical equipment or medicine, and then going from place to place, walking around the entire city. So that was a question, but we found we basically went to Google Map. We found the address and location of that pharmacy and her home, and we were able to pull and print out, indicate where her home was and where the pharmacy was. That was a walking distance. I mean, it would be actually more unnatural to drive from home to there. So she had this depot of all the stuff that she was distributing in her garage, and so she basically took there. So that impressed a lot the officer, and she got approval. I mean, I wouldn't say necessarily that was the reason why she got approval, but I think that was one of the high points in the case, that we were able to show that she probably walked there. So this was indirect evidence. The other indirect type of evidence, you have to be creative about this type of stuff. Basically what I'm trying to say. Other type of direct evidence, so we had a case, somebody went to a protest, and he claimed on that certain date he was there. He actually took off time from work and went to the protest. He had no pictures, he had no records, no communications, no evidence of him participating in that protest, other than what we were able to get from his employment HR records, that he was half day off that day. And when I asked him how you went there, he said, I took Uber. We pulled his credit card statement to show that he had an Uber payment on that day. Now, that didn't show where he went on that day. Well, probably his Uber account could have shown. I don't remember if we used that. But the bottom line is that that type of evidence doesn't necessarily say that he went to the protest, or he participated there, but at least it supports the evidence. So that's indirect evidence. You want to be as creative as possible, and that's one of the most commonly used. It's not that common to have photographs or videos of the incidents, medical records, police records. And if you don't have those, don't be alarmed. You can still get asylum, but you have to make all possible efforts and document those efforts to get those records as much as you can. So the next type of evidence, so we went through, let's recap what we went through. So we went through the direct evidence of your testimony as to what you suffered, what you witnessed, the background information, both in writing and orally. When you go to the asylum interview or immigration court, you have to be very consistent. Those two have to match. We went through the direct evidence, such as photographs, videos, medical records, police records. We went through indirect evidence, such as proof of things that don't necessarily directly demonstrate what you claimed, but it supports your story. The next type of evidence I want to discuss is letters from witnesses. So letters, evidence from witnesses, sworn statements, affidavits, and so on and so forth. And you can bring witnesses to the immigration court or to the asylum office, live witnesses. So what are those letters? So for example, if you have a relative or neighbor or colleague or friend who witnessed something happening to you, where they were direct first witness, they saw with their eyes what happened, that's extremely important to get an affidavit, sworn statement, a letter, and I'll go through the form of in which form you can get those things. So it's extremely important to get those witness statements. If you had a neighbor who saw that somebody came and asked for you while you were outside of your home country, and some police officer or local police or somebody came and asked for you. If you had medical provider, other than providing the medical record, maybe your friend or relative, somebody who is willing to do that, they're not scared to do that, they can provide a separate sworn statement or letter confirming this. You have relatives, the family members who know or who witnessed the injuries you suffered, or things that happened to you, or the fact that you were fired from job because of this or that. Whatever the witness statements are supporting, that's still going to be helpful. It's better than not providing any witness statements. Sometimes I get asked, for example, relatives who know things that happened to you, from your stories. This is like second-hand witnesses, not the first-hand witnesses. So for example, you were harmed and you were targeted, you were fired from your job because of your political views in the past, and at the new job you told your boss about this, or your colleague, and your colleague confirms in the letter that yes, this person told me that this is what happened to him in the past. So he's confirming that you told that person versus they knew or observed this happening to you. Those witness statements, I wouldn't necessarily classify them as helpful or not helpful. It's case by case. So those type of witness statements, which are second-hand knowledge witnesses, it depends on the case. If you don't have anything, maybe that's helpful. If you have more important witness statements, you don't want to disperse the focus from that by providing these second-hand witness statements corroborating the same as the first-hand witnesses are saying. It's case by case. Sometimes let's get or less for the second-hand witness statement. So it depends on your case. Discuss it thoroughly with your lawyer when you are preparing for your evidence in support of your asylum application. But one of the important questions that comes up is in what form should those witness statements be? So for example, if you have your parents who are writing a letter confirming you received a notice to appear in the local military department for conscription in the army, right? So which is now taking place a lot in Russia, and there are lots of individuals who are opposing the war in Ukraine, and they are, fleeing and asking for asylum. I'm just giving you this as an example. So you want to get a letter from your parents confirming this. Now, what would be the ideal way of getting this testimony from your parents? Obviously, that would be to bring them to the United States and have them appear in asylum office and immigration court, raise their hand, promise to tell the truth, swear to tell the truth, nothing but the truth, and testify in person to the judge, and give the opportunity to the other side to question, or to the asylum officer to ask additional follow-up questions. Now, that rarely happens, right? Because it's hard to bring your parents here. They may not have visas. They may not be able to get visas, or they may be even scared to come to the United States because the government in your country already knows that you fled here, for example, and so on and so forth. So it's rare. It rarely happens. But what's the next option? So if they cannot be live witnesses, what's the next option? Then you can get a written statement from them. Now, in which form? There is a completely wrong idea and rumors and gossip and perception that you have to get letters handwritten by the witnesses. Please do not, unless you're getting a letter from someone who absolutely cannot type, or who doesn't have anybody who can type it for them. Please do not get any handwritten witness letters, statements. Okay, that's ridiculous. That somebody came up with that idea. I don't know when and why, and that idea floats out there still. Lots of crooks that provide, asylum help illegally without having a license to do so, who are not attorneys, do that, tell their clients or tell those individuals they're illegally helping to file for asylum claims, to get witness statements as written by hand. Do not do that, please. I don't want to see any of my clients providing a handwritten witness statement. That's just useless. That's just ridiculous. Nobody handwrites anything at this time. Again, unless there is no other way. You're asking your grandpa to write a letter, and all they can do is handwrite. They don't have anything to type on, which is understandable. Or maybe it may be in such a country where things are so difficult and bad that maybe that's the only way to handwrite something, put it in an envelope and mail it, wait for weeks until it gets to the United States. It happens. But unless that's the case, do not absolutely ask for witnesses to handwrite anything. So the best way, obviously, is a notarized letter with a copy of the ID of the author attached to it. Now, in some of the countries, the notary is a government worker. So the witness from whom you're asking to provide that notarized letter may be scared to do so, because the notary, who's a government worker, is going to see what this witness wrote in that letter in support of your asylum claim. And they may be scared to put that evidence. So what if it cannot be notarized? That's fine. We'll get it sworn statement, in the form of sworn statement. Sworn statement is basically, instead of getting a notary to notarize, you would still attach a copy of the ID, but it will be, under oath. This witness is saying at the end of the letter that under the penalty of perjury, I, testify or confirm that the foregoing information is true and accurate to the best of my knowledge. So that's a sworn statement. Now we have a format, and that's what we provide, that format to our clients for those, and that can, instead of notary. Now, what if the witness is not willing to, maybe they're too busy, or maybe they are a witness, maybe your colleague or remote relative or acquaintance, and you ask them, they're saying, yes, okay, I will do, but they never get to actually type it up, print it out, sign it, and they're just hesitating to do that. Then you can send it to your electronic version with electronic signature, or even without a signature. So if somebody doesn't sign a witness statement, what is the other option? Is get an email from that person and print out that email body with the attachment showing that it was attached, and that proves that it came from this email address, whoever that author is. Get a copy of their ID again if possible. If they don't want to do an attachment to the email, they just want to write it in the body as a text in the body of the email. Again, that's also an option. It's better than nothing. So get that. If that's what that's not what they want to do, if they want to, send you a message through social media, like, Facebook or WhatsApp, that's fine. It's still better than nothing. Screenshot of them, writing this for you, or any kind of evidence. I had a case where a client of mine said that there was some kind of, he was also from Iran, and in that case, he received some summons to appear in court. And I said, how do you know that, you have summons? Because it arrived while he was in the United States. He said, well, my aunts who live there in the house where I used to live, they told me that they got this summons. I said, well, get them to confirm this, get a letter from them and get those summons. They said, no, that's not possible because they're not going to send it. They cannot email it. They're afraid to do so. Everything is being monitored. They're afraid to even, put it in the mail, definitely, but even email. So they cannot send those summons and they cannot send that evidence. I said, but how do you know that? Well, my aunts told me. I said, how do you communicate with your aunts? He said, I communicate with them over Skype. Okay, good. So next time when you talk to them via Skype, have someone recording. Nowadays, for example, Zoom allows you to record the meeting. So, but back then it wasn't recorded. So have your phone held on the side, record this, your conversation with your aunts to show you the summons, and video record that while you're doing this. So be creative. Again, anything is better than nothing. So if you cannot get a notarized letter, if you cannot get a sworn statement, a signed letter, then get a text. If not text message. If not that, social media, screenshot of you communicating with them and so on. The bottom line is be creative in the way of getting evidence. At least you show that you tried. The other way of being creative, if somebody is refusing to give you evidence or to write the letter to you saying that, no, I'm afraid. What do you mean? Keep me away from this. For example, we had a client who was a police officer in the past. He was told to attack and detain protesters. He refused to do so. He was targeted and harmed. Now his colleagues, his commander and so on, they were all sympathizing with him, but obviously in that authoritarian country where nobody can actually voice their concern, everybody was obeying those commands from higher ups to beat up the protesters. But this guy didn't, so he ended up in the US and asked for asylum. But I told him, okay, do you still have a good relationship with your colleagues? And he said, yes. I said, can you get a statement from them that you were targeted in your country because of this? He said, no, they wouldn't. Well, let's give it a try. So I told him in his social media, he was friends with one of his colleagues. I believe it was actually his commander. I told him in social media to write a message to this guy. Now, in your message, state what happened to you and say, hey, can you confirm this when on this day I was this, and when our commander or the chief, major told us that that I have to go and do this, or I will, or whatever will happen to me. Can you confirm this? So he wrote that in the social media, and the guy on the other, all this, I don't want to get involved. So that was evidence that this guy first attempted to try he attempted to get that testimony from the witness. And number two, that the fact that this guy says, no, it didn't happen. What are you talking about? He actually wrote back saying, please keep me away from this. I have kids and family. So that shows even more that this guy, the witness, not only confirmed by refusing to confirm, but also how serious the situation is in that country, that even somebody who could just confirm and say, yes, I confirm, is not willing to do so because they're afraid of being targeted. So anyway, with that example, I want to make sure that you understand you should be creative and you should make all the efforts to try to get those records. Okay, so the next type of evidence is one that is often neglected by even some lawyers, unfortunately, but by a lot of individuals who are applying for asylum for themselves, is country reports. The reports, articles, the reports of the international organizations, and obviously a report from the U.S. Department of State on the country conditions. Now, why I say it's neglected? Because I see sometimes cases where it's just a State Department report, but there is no other report that is relevant to the case that shows similar situations. Some reports may be in different language and they need to be translated. Some of the articles may be directly on point. I had one of the cases, it was from Russia many years ago. It was Yazidi individuals, and they had a house burned. Their relative's house was burned and the kids died inside. And we provided, obviously all the reports about how Yazidis, Kurds were treated in Russia as ethnic minority. But that wasn't enough. Now we were able to find a printout of a local newspaper that at one point, was like years before that case, published this. Basically it was just almost like a very local news, community newsletter, which said, unfortunately this house was burned and this happened. And this was in Russian language, and we got it translated. So that was very important country reports. It was also basically, I would classify it maybe as evidence, not a country report, but it was a news report, so that's also helpful to show. So country reports are very helpful. It educates the asylum officer or the immigration judge. It shows that there are these cases that are prevalent in this country, that the human rights are being constantly abused. One of the other issues I see in many cases of country reports, people submit very general country reports. Okay, this country has lots of corruption, there is a lot of human rights abuse, disrespect and so on, freedom of assembly and no freedom of speech. That's not relevant to many of the cases. Okay, so you do want to provide those, but don't just rely on those. You want to narrow down the specific issues in the country reports, specifics and relevant to your case, and you want to highlight those portions. So for example, State Department report, usually consists of hundreds of pages. You don't want to just dump it in your case and give it to the judge. Here you go, find what's relevant. You want to highlight. Now, what you highlight in those reports is very important. If you just highlight the general things, this country has human rights abuses, has corruption, and so on, it's not going to be as helpful as highlighting the relevant portions. For example, we have many cases where relatives of the dissidents are being targeted, and that's considered a particular social group, or it could be also classified as attributed or imputed political opinion. So we have that, and some country reports, like State Department report, contain information that there was this incident of this dissident whose relatives were targeted because of his or her activity abroad. So if you highlight that portion, that's a lot more important than showing, highlighting in the country report the general country conditions, how there is disrespect of freedom of speech and so on. Yes, again, that might be helpful, but that's not as direct as on point. Now, when you organize the country reports, start with the first priority, with the highest priority. Usually the State Department report is the number one we put there, and then follow with whatever is most relevant. You get, if it's a religion-based case, you have U.S. Department of State report on the religious freedoms, which is separate from the State Department report. Then include that. So most relevant. So next type of evidence is expert report and expert testimony. That is one of the most important also types of evidence in many cases in immigration courts. In asylum offices, I would say maybe in about 25–30% of cases, we recommend expert report. Usually there is no expert testimony in asylum cases. That doesn't come in. The asylum officer decides who they want to question or not, and they wouldn't question even if you bring the expert to the asylum office. But expert report helps to include in your asylum case, but asylum officers, unfortunately, they're not as trained as they should be. Unfortunately, they don't have, many of them don't have legal education. They're not lawyers, they're not attorneys, they're not judges, they don't know what expert testimony necessarily means. All they see is just somebody, you paid for writing a report supporting your case. And sometimes it doesn't really help much. You may be spending money on the expert report. But in immigration courts, expert reports are very helpful. It helps a lot to kind of put everything in the context for the judge. I had one case where I had to prove that the judges in the country of my client were so corrupt that they were basically doing, whatever who pays them more does. And this judge in immigration court, was a very experienced judge who's been on the bench for many years. He was a little bit kind of puzzled. Well, he didn't believe it. It didn't sound believable to him because, he knows that there are judges that are corrupt, but to the extent that we had to demonstrate in that case, that judge was skeptical of this. Like, how come put a judge, all of the judges in that country of this person, how come they could be so corrupt? That maybe was also kind of touching the pride of this judge because, it's his colleague, the judge, and hearing that much of negativity about the judge's actions in that country was unbelievable to this judge. So we brought an expert. Not because of this issue, the expert came no matter what, but the expert testified, and I asked those questions about this expert. And that expert, as an independent person, not me as the advocate for my client, but this independent expert, convinced the judge how bad are the country conditions in that country related to the judicial system. So that was extremely important. That was extremely helpful. So that's why sometimes you see experts are very helpful in immigration courts, most of the times, to educate, to kind of give the summary of the country conditions and to tie it together with your case, with the specifics of your case. You're saying that this happened to you because of that. The expert confirms in the court to the judge that, yes, these type of things happen a lot in this country. And that's why, it's not objectively unusual to hear this respondent's, this applicant's case, that this has happened to him or her. So expert testimony is also very helpful as another type of evidence that I usually recommend a lot in immigration courts, but sometimes in asylum offices. The next type of evidence is evidence of good moral character. Sometimes we have clients insisting on providing that type of evidence, but it's case by case. So it depends on your case. What is evidence of good moral character? It means the things that you've done in the US while you were here. Now, let me back up a little bit. Where does this come in? The evidence of good moral character, why it may be even relevant. Asylum as a form of relief is a discretionary relief. It's a humanitarian relief, and the judge and the adjudicator have discretion. It's not unlimited discretion, but they have a discretion to consider that this person, I don't know, he's not a good person. He's a liar, cheater, he did a lot of bad things. Even though by law he may deserve asylum, we're not going to give it to him. So evidence of good moral character affirmatively helps to preempt that kind of negative discretion decision. So, but usually it's not, you shouldn't be affirmatively providing, hey, I'm a good person, I take care of my kids, or I volunteer in school, or a coach, or do whatever. That can distract the focus from your case. You want to appear tough. Here's what happened to me. Here's what the law says. I deserve asylum. That's why I asked for asylum. You want to be respectful about it, but you also want to be cold about it. You don't want to be praising the United States or so great country, or sucking up to the judge or asylum officer. No, you want to be firm on that you deserve asylum. You want to get asylum. So evidence of good moral character is almost like saying, maybe I have a weak case. Maybe you can deny it to me, but I'm a good person. Give me asylum. That's not going to work in most of the judges with most of the officers. And you providing that might be showing the weakness in your case. It's just a psychological psychological thing. So I don't recommend it in every case. But if you have a minus in your case, for example, you had some kind of negative criminal history, you've been charged in the United States, things happen, you've been convicted of driving while intoxicated, something happened, you have some kind of negative history in the United States, then you want to rehabilitate yourself by demonstrating, you rehabilitate your good moral character by providing evidence. What kind of evidence you can provide? Maybe your tax returns for the past years you were in the US, volunteering records, letters from people in the US, letters from your kids, school teachers, other parents, neighbors, community members, church, providing that you're a good person here in the United States, you've been contributing to the community, to the economy. Maybe you have a business, you have employees, and you want to demonstrate that. Again, don't use it as a bargain chip for getting asylum. It's not going to work. Even if you have a great business with a bunch of employees, it's not going to give you asylum if you don't have basis for asylum, if you have a weak case. So focus on the merits of your case, on the facts of your case. That's most important. The other type of evidence of somewhat good moral character, or maybe just helpful evidence as a discretionary factor, is family ties in the United States. So if you have US citizen mother, US citizen father, brother, sister, child, relatives, close usually, I would limit that. Then you provide evidence of that, that's helpful. Again, don't overuse it. Hey, my brother is a US citizen, give me asylum. That's not going to work. Then the next thing I want to talk about is translations. So when you provide evidence, a lot of these documents you may be obtaining from your home country may not be in English. You need to get those translated. All right. Number one rule is doesn't have to be notarized. I get asked this a lot. Does it have to be notarized? Does the translator have to have some kind of certificate, be certified? No. The rule in the United States is that anybody who speaks both languages can translate as long as they provide their name, information, address, phone number, preferably also email address. They sign and they certify that they're fluent in both languages, and under oath they're certifying that they translated accurately from whatever document was attached, was translated. So it doesn't have to be a certified translator, doesn't have to be notarized signature, no colorful stamps, ribbons, or anything. It's not going to impress anybody here in the US. It may work in the countries where applicants come from. They like stamps, colorful ribbons, and so on, but not here. All you need is a very good professional translation and certification. Now, make sure the translation is done correctly. It doesn't matter what the document says in your language, the original document you obtained, as much as what it says in English. So if the translator makes mistakes, if the translator misses the points in the translation, then it weakens your case. So make sure you have a very professional translator who has done this before for immigration cases, for asylum cases, and they know what they're doing. They're going to verify. They're not going to just use Google Translate, as I know some translators do, but they may use it as to assist them in translation, but they're going to get, verify and confirm all of that translation. So translation is important to get a professional translator to translate, whether it's country reports, court records, any evidence. Next, I want to talk about organizing the evidence, how to organize. As I said, in terms of country reports, when you organize evidence, usually start with the most important. You have the most direct evidence, most, supportive evidence for your case listed first. Put a table of contents. It has to be. Some, unfortunately, law firms that are just, doing this as a sweatshop and just charging less so that they spend less time on their clients' cases. They just submit the evidence. It's not paginated. There are no page numbers. There's no table of contents. There are no tabs, and nobody pays attention to organization of the file. The judges hate that. The immigration officers, the asylum officers hate that. So make sure you have clear table of contents. If you're working with a lawyer and they don't do it, demand that they do so. They have to have page numbers, because you have table of contents and there is tab A, tab 2, tab exhibit 1, exhibit 2. The asylum office, before the officer gets, removes all those tabs. So if you have page numbers with the table of contents, that helps a lot. So it helps a lot also to address your evidence, to find your evidence easier for the immigration judge or the asylum officer. And finally, I want to talk about updating evidence. So another frequent mistake is people file their asylum application, they provide witness statements, they provide country reports, they provide records, and then they have their interview or their immigration court hearing, individual hearing many years later. And during those years, things change, things happen, new things take place. For example, your relatives, whoever lives at your place, or it could be your parents, other relatives or colleagues, somebody may tell you that, oh yes, so well, this is what happened. Somebody came and was looking for you, or we had a police officer stop by, or we received these summons and so on. If you don't update the statement from that witness by supplementing before the hearing, and there are certain deadlines in asylum offices and in the immigration courts by which you can update, then that's not going to be helpful. And doing so, providing this new information, oh yes, by the way, my neighbor told me that somebody was looking for me, then the question is going to be, why didn't you update the statement which you already had from neighbor? Why didn't you get a new statement? Why didn't you get a supplement? Country reports updates. So you may have submitted the country reports, 5 years, from 5 years before the hearing date. Now, things happen, things change. There may be a lot of more relevant information between then and now. So get updated evidence and update evidence before your hearing and before your asylum office interview. So I hope this provides you a detailed summary. I know it's been a long video, long recording, but evidence for asylum cases is a very important topic, and that's why it deserves such a long video. If you find this information helpful, if you find it helpful for your case, please press like, please press thumbs up, and please subscribe to our channel for more information that might be helpful for your case. Thank you very much for listening. Bye-bye.